Welcome to the Ernie Chambers Show.
Brothers and sisters, friends, enemies, and neutrals. Last time I was talking about some of the activities of mine in the legislature, and I ran out of time before I ran out of material. And so I'm going to touch on a few more things. But what I intended to do mainly was talk about some of my activities in court, handling my own affairs. These books comprise what is called a transcript or a bill of exceptions. I went on trial on a traffic ticket in 1980. This bill of exceptions, meaning the entire amount, runs to 735 pages. The ones who were accusing me were all employees of the State Patrol, but they also had the manufacturer of the radar device that was used. They had the supposed engineer who designed this device. They had the officer who gave the ticket. They had the person in the State Patrol who trained officers in the use of this device. They had a captain who was over the entire operation. And I was going to go through some of the cross-examination that I did, but I decided I want to finish what I started about my legislative activities. However, I'm going to go, like you might want to do in a book, to the last page to see how it all turned out. Let me see if I can find that now. This is to generate suspense. Are you in suspense? Anyway, the court had made a comment at the very end. And instead of trying to find those exact words, because they were hidden and buried in all of this, the judge had said, we've been here and we've had several days of testimony. And here's the end. The court, at this particular time, and this is on page 734, at this particular time, the state is required to prove beyond a reasonable doubt that the defendant is guilty of the crime speeding 66 in a 55 zone. The court, after hearing all the evidence, the witnesses, and all the exhibits that were received, we've been here some three and a half days and have numerous notes, 25 pages of notes, and he held up a legal pad. The court at this time finds that the state has not proven its case beyond a reasonable doubt and finds the defendant not guilty of the charge of speeding 66 in a 55 zone and orders the case dismissed. Mr. Chambers, thank you, Your Honor. After all of that, but it was one of those situations that didn't end the way I wanted it to end. But often life throws us a curve. And I had pointed out that I was sorry that I won the case. If I had lost it, then I could have appealed it to the Nebraska Supreme Court, and the court would have imposed some rules on how radar and other electronic speed detecting devices would be used. But I was too good and effective for my own good in terms of what I hope to achieve in that case. I will find that article, and maybe when I come back next time, I'll have it with me. But I did bring some things that I want to touch on from last week. I'm troubled in a way by the fact that we as a community, white people are poorly informed also, but see, they run everything. They don't have to be competent. They don't have to be qualified. I, one black man out of 48, there are 47 of them, and I did more to get my way than all of them together in terms of their being able to stop me. And yet I'm supposed to be the inferior one. Let me pick up where I left off. I talked about how the white people had enshrined me in their legislative rule book by enacting rules to try to stop me, and they never worked. But they crippled the white senators because they didn't know the rules, they didn't read them, they didn't understand them, didn't know how to apply them. So the weapon that they created to hurt me did not hurt me, but it turned on them. So I was enshrined in their rule book, enshrined in their statute book, and then enshrined in their constitution through the adoption of term limits. And I'm not going to read everything that I've got, but a few items. This is dated February of 2000. And the World Herald is writing about what somebody wrote to the Public Pulse. The editor wrote, and this guy who wrote this was from Iowa. P.L. Butcher's Pulse letter illustrates a reason this newspaper has opposed term limits for legislators. If a senator's constituents want him or her on the ballot to stand for re-election, that's their business. For the voters of an entire state to keep the senator off the ballot using a term limit strategy would be a clear case of tyranny by the majority. That's what the World Herald said when this fool from Iowa asked, why is Chambers still in the legislature? I thought term limits. Well, they hadn't come into effect yet. Here is something that was written 5 years later, 2005, and it's headlined, Legislative Term Limits, a Self-Inflicted Wound. Some information that the World Herald included about the writer. His name is Lee Rupp. The writer, who lives near Monroe, Nebraska, was a Nebraska state senator from 1983 to 1987. He was a Nebraska Game and Parks Commission game fisheries biologist before his service and a University of Nebraska vice president and director of legislative affairs after his service in the legislature. And this is what he wrote. Then there's what I call the Ernie factor. Incredibly, I've heard otherwise rational people say in effect, quote, it is worth it just to get rid of Ernie Chambers, meaning term limits. There is a delicious irony in this, which would be humorous if it were not so serious. First, Ernie's legacy is now probably forever guaranteed. As a state, we have acknowledged that his power is so immense, we had to alter our Constitution to negate it. Second, haters of government in general, at every opportunity that the legislature, wait a minute. Second, haters of government in general lament at every opportunity that the legislature passes way too many laws. So how do they remedy that? By getting rid of Senator Chambers, who through his well-reported tenacity and ability in extended debate has single-handedly squelched more bills than anyone in the history of the legislature simply by running out the clock on the constitutionally limited legislative calendars. And he called getting term limits a self-inflicted wound. They got rid of the man who was doing what they were upset about. So because they changed the Constitution to get rid of me, it led me to write what I call an ode to idiocy and racism. Nebraska racists suicidally bumbled. How can a lone Black man be humbled? When cowardly lynchers went to do a job to get one Black man, they always took a mob. Though the racists branded him inferior, given their conduct, they deemed him their superior. The land of the free and the home of the brave? No, the land of the tree and home of the slave. One Black man, their minds he so deranged, their state constitution to get him they changed. He mocks them and taunts them, raising their hackles, dismissing them as skulking, yapping jackals. If they've any shame, it's now plain to them. By their craven racism, they've elevated him above Nebraska's fundamental law, regarding him with fear and ineffable awe. They made me more important than their Constitution. Here's what I wrote in the year 2000 when they were considering this madness. And the World Herald headlined it, Measure 415 aims at me. It was constitutional provision. The number given to it was, or the title, Measure 415. Initiative 415, though officially dubbed the Term Limits Amendment, actually is the Get Ernie Chambers proposal. Already embedded in the history of Nebraska, I now stand on the brink of being enshrined in the state's constitution. Were I a man to gloat, why would I be gloating now? Because my overpowering presence has set in motion an implacable force that will accomplish, as to the legislature, what the sinking of the Titanic could not. When the Titanic went down, there were survivors. When I go down, will any legislator survive? As says the hymn, no, not one. If Initiative 415 wins at the polls and is constitutionally sound, I and other legislators on the ballot November 7th will be limited to 2 consecutive terms or 8 years, while those elected 2 years ago will bite the dust in just 6 years, because Initiative 415, contrary to what its proponents have misrepresented, is retroactive. Thus, half the total of white Nebraska's representatives will exit the scene before me. The remainder, should I win a second term, will be forced out at the same time I am. Seldom can a person deliver on the oft-stated warning, if I go, I'll take everybody with me. I like to taunt these white people, get the better of them, turn their strongest weapon that they thought against me, against them, and show how stupid, how genuinely inferior, how lacking in ability they are, how they've been spoiled and privileged so much all their life that when a Black man who had been assigned a place got out of that place, was uppity and would not obey them and mind them and do what they wanted, they were willing to vote against their own interests and demolish the legislature as an institution to try to put him in his place. And they did term limit me. But after I sat out for that 4 years, I came back and did 8 more. But anyway, getting ahead of this, if I'm not simply being arrogant, presumptuous, and egotistical, why do I assert that 415 is aimed at me? The organizers and leaders of the term limits effort, as well as other white people throughout the state, forthrightly admit that bouncing me from the legislature is the driving force behind the campaign. During my long political career, I am accustomed to being in the eye of the storm. Guy Curtis of Imperial, who is chairman of the Term Limits Committee and leader of the PAC, has not been bashful. Last year, during the signature gathering phase, the World Herald reported on May 22nd, 1999, quote, group leaders have mentioned Chambers by name when they argued the need for term limits. Guy Curtis said Chambers is influential because of his long term of service. No, I'm influential because of my ability. It was just demonstrated for a longer period of time than anybody else had been there. Less than 2 months ago, a World Herald article about a poll favoring term limits revealed the arrogance, enmity, and paternalism of Mr. Curtis when the words of the story, quote, said that veterans such as Senator Ernie Chambers are allowed to garner too much influence and power. I don't think it is right, Curtis said, that he is re-elected and has the advantage of name recognition and has been in there forever and nobody else has a chance. That's what this white guy said. 2 days later, a World Herald editorial opined, quote, there may be substantial numbers of Nebraskans who would like to see Chambers retired, but if they don't live in his home turf of District 11, what business should it be of theirs? His constituents, whose voice should be the only one that counts, have kept him in Lincoln since his first election in 1970, unquote. On September 28th, State Senator Bob Wickersham of Harrison, who has been in the legislature since 1991, was addressing a conference of Nebraska Association of Resource Districts in Kearney. Quote, Wickersham was even more blunt in his opposition to term limits, particularly when it comes to people he has heard say they support term limits as a way to remove controversial Omaha Senator Ernie Chambers from office. Quote, at the same time you're going to get rid of somebody you like, that's what you're going to do. That is way too narrow a base for a very, very important issue to this state. Nebraskans are not alone in wanting me out of the way. An Iowan stated in the February 18, 2000 Public Pulse that there are, quote, several compelling reasons, unquote, for term limits, and referred to my statement that I own the legislature. That upset that white man in Iowa so much. Not even in a member of the state, a citizen of this state, is why I should be term limited out. White people are petty, stupid, and they manifest it and put it in their constitution for the whole world to see. Then they want to deny it and get upset when somebody tells them what they look like based on the paint they used to paint themselves. And the World Herald then responded editorially in the way that I mentioned. What business is it of anybody who doesn't live in the district I represent? And when the people outside that district, well, let me read their statement. For the voters of an entire state to keep the senator off the ballot using a term limit strategy is a clear case of tyranny by the majority. That's what the World Herald wrote. I'm going to skip some of this. Incidentally, in his October 16th Another Point of View, Guy Curtis, the leader of the PAC, neglected to mention, while scratching for votes, what he trumpeted while hustling signatures to put 415 on the ballot, namely that Senator Ernie Chambers is the target of the effort. Lee Terry Sr., father of Representative Lee Terry Jr., wrote Another Point of View on October 30th. He was opposed to Proposition 415. He stated, quote, the problem is, let's admit it, that some think State Senator Ernie Chambers has been in office too long. I agree, but who are we to tell the people being represented that they can't keep him? Who are we to invent some automatic pilot ejection system that would deny voters the right to keep their preferred representation, unquote. Being accorded such significance and granted such control over my detractors makes it exceedingly difficult to remain modest and humble. But I try. After all, it is an extraordinary man who dominates the Constitution amending process of a state, especially when he is a member of a group constituting less than 4% of the entire population. To such a marked degree have I apparently disordered the minds and inflamed emotions of most white Nebraska voters that they crouch, poised to leap into the abyss in order to enshrine me in the Constitution, while at the same time getting rid of all of their own representatives. That's called cutting off your nose to spite your face. Despite my impending enshrinement, I have to admit that 415 would befoul the Constitution and pervert the cardinal principle of democratic elections, one's right to vote for the person of one's choice. Former U.S. Supreme Court Justice William O. Douglas said in one of his opinions, quote, "There is more to the right to vote than the right to mark a piece of paper and drop it in a ballot box, or the right to pull a lever on a voting machine." He was quoted by the U.S. Supreme Court in Reynolds versus Sims in 1964, where the court itself fleshed out the idea by writing, "The right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government," unquote. Thus, I'm continuing now my comments. When the voters are precluded by the Constitution from voting for and electing a person of their choice, the vote itself is denigrated and drained of value, and form is elevated above substance. A pro forma vote may be cast, but the voter in effect is voting for nobody. Underlining the distinction between the legislative and executive branches of government, the U.S. Supreme Court said, quote, "The legislature is the only instrument of state government directly representative of the people," unquote. Of a truth, I own the majority of white Nebraska voters when I can provoke them into voting against their own interest. And I do own the majority of white people because I make them make fools of themselves. What must their children think of them? What will their grandchildren think of them? All of this was done to stop one black man. He couldn't be in the legislature forever. And were the other 48 members so inept that they had to pass rules against him, and he got around the rules and beat them at their own game? He stopped their legislation when it was bad by using their rules. He passed his legislation following their rules. So you've got a lawmaker, and you all become lawbreakers, and you're the master race. No, au contraire. You all are detrimental to the principle of white supremacy. I'm finishing up then the piece that I put in the paper. In conclusion, I concur with Mr. Curtis and all the rest who are convinced that only a constitutional amendment can dislodge me from the legislature if I choose to remain there. For example, I was re-elected by write-in when I was on the ballot for U.S. Senator against Bob Kerrey, and my name wasn't on the ballot for the legislature, but I won by write-in, running for 2 offices at the same time. Because of the unique relationship between me and the people in my district, I'm constrained from simply walking away from the legislature by choice. If I should serve 2 more terms, I will have given 38 years of my life to public service, not only to the people in my district, but throughout the state. 38 years is too long to do almost anything except live. Therefore, to other legislators, term limits is a death sentence. To me, it is parole. Still, as a voter, which I'll continue to be after exiting the legislature, I resent being precluded from voting for whom I choose for as long as I choose. But after sitting out 4 years, the people in the district brought me back for 8 more, and I didn't spend a nickel to campaign, and I got elected anyway. Then here's something that appeared in the World Herald just last year. I'm not going to read it all, but this woman was writing about the damage done to the state as a whole since the Nebraska Constitution was amended to limit state senators to 2 consecutive 4-year terms. The inherent advantages of incumbency have dwindled. In days gone by, long-serving incumbents had little need to seek out campaign contributions since they often faced only token opposition or ran unopposed. At the time term limits went into effect in 2006, there were so many vacant seats that both parties jumped in to recruit candidates, usually dependable party loyalists. They also lined up well-heeled, dependable donors, also party loyalists. Donations that previously had been local or issue-based were now more along partisan lines. These fledgling candidates needed money and lots of it to break through the 24-hour news cycle to get known. The result was the newly elected freshman senators tied to their partisan benefactors in a way that had not occurred before term limits. In 2015, political scientists Seth Maskett and Boris Shore determined the Nebraska unicameral had become the most rapidly polarizing state legislature in the nation, and it was due to term limits. To an increasing degree, the unicameral is now controlled by elite partisan donors who employ the best lobbyists money can buy. If senators stray from the party line, the well-timed in-session fundraisers hosted by lobbyists work wonders to guide them back into the fold. Stiff consequences are meted out to senators who resist party discipline, often through the dreaded dark money attacks in the final days before an election. There is plenty of blame to spread around, but mostly we Nebraskans need to take a hard look at ourselves. Now, this was written last year. Many voters supported term limits because they wanted to get rid of longtime state senator Ernie Chambers. But in voters' eagerness to turn out the unicameral's only African American state senator, was it worth changing the Nebraska Constitution? The ugly underside of term limits is that the unicameral is now nonpartisan in name only, and control of the legislative process has transferred to the lobbyists in the pay of partisan elite donors. So when they got rid of me, they got rid of the heart, such as heart there might be, and the soul, as such soul there was, of the legislature. So they voted against their own best interest. So I, as a Black man, controlled them and did to them what I chose to do to them. And while I was going through that, I have more than one part of my mind that can work. So I was puzzling over where was an article that I wanted to read. And it occurred to me that it was in this book of transcriptions of that long case, over 700 pages of testimony, witnesses, and exhibits, which I won because I prevented the state from proving their case beyond a reasonable doubt. There's a song, a hillbilly song that says, "Po, po, pitiful me." There I was in that courtroom in a small town, Plattsmouth to be exact. There were several representatives of the state patrol against me. There was the manufacturer, the one who ran the company that manufactured the device that was used in their camp against me. As I told you, the engineer who designed the device over there against me, and the state was captioned State of Nebraska versus Ernie Chambers. All of those powerful, intelligent white people against me. And as the judge pointed out, we spent several days there. They called witnesses, presented their evidence, their expert testimony against this po, pitiful Black man. But bless Peter, the state couldn't prove its case beyond a reasonable doubt against this one man. This is the article that was written about that. It was written June 25th, 1980. Radar issue remains. Headline, Chambers win disappoints. World Herald staff writer Bill McCoy wrote the article. Plattsmouth, Nebraska. Both State Senator Ernest Chambers, the defendant in a speeding trial that ended Tuesday with an innocent verdict, and Cass County Attorney Ronald D. Moravec, the prosecutor, were disappointed that Chambers won. Both told the World Herald that a higher court might have clarified rules on police use of radar if Chambers had lost an appeal. Quote, the only way to go to the Supreme Court would be to lose, said Chambers, who defended himself in the 3.5-day non-jury trial. My goal was to have this case appeal to the state Supreme Court. Because the legislature is unwilling to impose rules and regulations on the use of radar, I was certain the Supreme Court would. Chambers, chairman of the legislature's Law Enforcement Committee, called the verdict, quote, a tribute to my legal ability, unquote. Moravec later agreed that it would have been good to get a clarification. In a recent Miami, Florida case, doubt was cast on the efficacy of radar, he said. Chambers cited several such court cases in Wisconsin, Louisiana, and elsewhere during his final argument Tuesday. Cass County Judge Jeffrey Campbell found Chambers innocent of driving 66 miles per hour last November 28th in a 55-mile-per-hour zone on Interstate 80 near the Greenwood interchange. If convicted, the fine would have been $12. I did all this to avoid a $12 fine, but I had a bigger fish I wanted to fry, plus court costs. Under Cass County traffic fine schedule, 1 point would have been deducted from his license. Chambers says he has a full 12 points. Chambers argued that a Nebraska State Patrol radar device was not reliable enough to prove he was speeding, and that the operator of the device, the man who trained her in its use, and 2 representatives of the company that manufactured it were unable to use it properly or efficiently. They couldn't do it. The judge simply said the state did not prove its case. He issued no ruling to explain the verdict. He said later that one side simply failed to win its case in the trial. The judge declined to discuss any specific flaws in Moravec's case, saying the state could appeal the verdict. Moravec could appeal in order to determine a point of law, but not to change the verdict. No appeal was announced Tuesday because he knew he didn't produce enough evidence, and I demolished their case during those 3.5 days, that if they couldn't win at the trial level, they certainly couldn't win before the state Supreme Court. I'm gonna say like Ali, I'm a mean man when I'm in that arena. Quote, the judge didn't say radar was bad, Moravec said. He just said we didn't prove our case beyond a reasonable doubt, unquote. Well, what else was he saying? Radar was being used. You, prosecutor, argued that your person operating it did so properly. You argued that the radar device was in proper working order. So if it's working the way it was designed to work, the operator was operating it in the way it was designed to work, but it didn't produce the evidence to convict, how can you say that radar is good? But see, those are the questions white people don't consider, and they certainly don't take a black man seriously, and they count on that privileged position of getting by while presenting an inferior case. And I, as a black man, it's like was said, the rabbit knows more about being pursued and pursuing than the fox, because the fox is running for his dinner, but the rabbit's running for his life. This prosecutor was used to having people plead guilty, and those who didn't plead guilty didn't know enough about the law to win. I studied, I was prepared, and the rabbit turned the tables on the fox. Instead of the yapping hounds killing the little fox, the fox outsmarted the hounds. Chambers asked if he failed to gain the impact he thought stated. I'll put it this way. Whenever something happens that I'm involved in, it will have repercussions beyond my case because it makes people aware, unquote. The trial involving testimony from a state patrol captain, 2 expert witnesses, and the state trooper who issued the ticket started about 2 weeks ago and was continued twice. The state even had continuances. Chambers argued that 2 expert witnesses, representatives of the company that makes the radar device, gave conflicting testimony that the calibration of the device using tuning forks did not prove its accuracy. The tuning forks presented in court were not necessarily the same ones used in the case, and that accuracy of the device depends too much on the experience of the operator. And the operator's experience, I successfully challenged it. They couldn't prove that the tuning forks that they brought to court were the ones they used to set up a frequency that would make the radar register in miles per hour, that frequency. I knew all these things when I went to court. These are white people, the master race. Do you see why I had so much contempt for these white men? Got everything their way, everything under their control, and still they lose when somebody stands up to them. Moravec argued that Chambers presented, quote, a general attack on radar, unquote, but not on radar used in the case, and that Chambers was relying too much on testimony given before his legislative committee, not in court. If that was the case, why didn't he argue that way in court? Why did he wait till it was over and he needed an excuse and an alibi, so he concocted one that he could give to a reporter? That's the way white people do. They create things out of whole cloth, pull things out of the air, and it's right because somebody white said it. I don't accept that. And that's why I'm not in the legislature right now. Had there been no term limits, I would have run again, and I would have won again, and I would have run the legislature again. Nobody was happier that I couldn't run again, than Ricketts. I call this other senators Ricketts Crickets because he literally purchased a number of them with his daddy's money. and they were his tools. And I stood up to Ricketts and I beat him on the thing that hurt him the most, and that's the death penalty. Overrode his veto, but then his daddy's money came into play. They hired petition signature gatherers, got enough signatures, used my name to say this is the way to get Chambers. And then they worded it in such a way that it was confusing. If you wanted to retain, if you wanted anyway, they had worded it in such a way that if you voted no, you were voting the opposite of what you intended to vote for. The Supreme Court should have not allowed that to go on the ballot because it was deliberately and intentionally confusing. And there were people who, after the fact, had it explained to them what they had done, they said they voted the opposite of the way that they intended to. If you voted yes, based on the ordinary understanding, you were voting no to what you wanted. If you voted no because you thought that would be a vote against the death penalty, you voted against what you wanted. So trickery and treachery are the stock in trade of most white men in positions of power and authority. And as I wrap this up, I would say that people should pay close attention to what's happening with that congressional committee called the January 6th Committee. If they have any more public hearings, then you ought to watch them. There's a young woman named Cassidy Hutcherson, and she gave excellent testimony in detail that undermined and undercut all the stuff that Trump had lied about. She talked about how Trump tried to take the wheel of the Secret Service driver who was going to drive him back to the White House, and he wanted to be driven to the Capitol building where the rioters, the seditionists, the destroyers were. And the Secret Service man wouldn't let go of the wheel. And this young woman could not be shaken up. She did not stammer, stutter. She said what she said. She knew what she was talking about. And this I'm making up. But there was a fly on the wall, and listen to two of Trump's supporters in Congress. And one of them said, when that woman was testifying for her, when she was testifying, I saw her as Joan of Arc. And this guy said, wait a minute, we're for Trump. You saw her as Joan of Arc? You saw her as a saint? He said, no. I saw her as being burned at the stake in the way that Joan of Arc was burned at the stake. That's where these white men usually can bully white women. They have white women voting against their interests when they vote against abortion. If a woman is raped, then, and she got an abortion, she's committing a law, a crime. And if a doctor performed the abortion, the doctor commits a crime. So the rapist can laugh and tell the woman, you're carrying my baby. You're gonna have my baby. You say that I got bad genes, well, you're gonna bring some more of those bad genes into the world, whether you like it or not. And these white Christians love that because they love to make other people hurt. And the wealthy white people will be able to get abortions. And they will have doctors who specialize in abortions for these privileged white people. Thus it always was, thus it always will be. And if they have to travel overseas, they got the money to do it. It's going to be that poor woman of all races, but it's going to impact Black women, especially because there is a disproportionate crippling of Black women when it comes to medical care anyway. And more Black women die in childbirth than white women. So if she has a bad pregnancy and it could take her life, she cannot get an abortion. The way these racist dogs and the fools who are married to them would have is this woman die and the fetus will die anyway. This last thing, then I'm through. The committee is going to invite Clarence Thomas's mistress, and by that I mean he's a slave and she's a slave owner, Jenny Thomas, she's from Omaha, who is still one of those who are saying that the election was won by Trump. The committee is thinking of asking her to testify, and Liz Cheney, who is a Republican, and they've threatened to try to get her defeated out there in Arizona or wherever she came from. And she said the work that she's doing on behalf of this country and democracy by serving on that commission should lose her seat that she holds in Congress. It's worth it. Her country means more to her than that. Democracy means more to her than that. And she said that she hopes that this Jenny Thomas will come voluntarily. But if she doesn't, then they're considering issuing a subpoena. Now, as I always close it, in the words of the canary who was told that the door to the cage was ajar, I'm out of here.
Thank you for watching The Ernie Chambers Show. If you'd like to make suggestions, email us at ewcfacts@gmail.com. That's ewcfacts@gmail.com. This has been an EWC Communication production.